This program is brought to you by Emory University.
Greetings, everyone. We're about to begin. I encourage you to take your seats. So I'm Babinski, the Dean of Emory Law, and it's my pleasure to be the first of a short program of introducers for today's Global Leaders Lecture Series program. It's one of the things that drew me to Emory Law was seeing the long record of bringing speakers here and promoting debate about some of the most important issues facing our society. Today, of course, we get to discuss the always timely and important topic of governance and the internet, looking at the mixture of debates and threats and opportunities created by that important topic. Our speaker is David Kaye, who's UN Special Rapporteur on the right of freedom of opinion and expression, and the author of the recently published book, Speech Police, The Global Struggle to Govern the Internet. And as I mentioned, this is part of Emory Law's Global Leaders Lecture Series that brings together national and international leaders to debate important topics for our society. And that lecture series is sponsored by Emory Law's International Humanitarian Law Clinic, which works directly with international tribunals, militaries, non-governmental organizations, and other entities to enhance protections during wartime and to promote accountability for war crimes, genocide, and crimes against humanity. That clinic is led by Emory Law Professor Lori Blank, who also directs the Center for International and Comparative Law. And Professor Blank will come forward to introduce our speaker today.
Thank you, Dean Babinski. Good afternoon. It's a great pleasure to welcome you all to the third Global Leaders Lecture, and a privilege to introduce our distinguished speaker on both a personal and professional level. He's a great colleague and friend and a tireless champion of international law and promoter of and protection of human rights. So, in fact, our speaker today exemplifies the motivating reasons behind the Global Leaders Lecture Series, which we launched in 2016, bringing national and international leaders to Emory to engage with our community on the promotion of the rule of law as an instrument of national and international security. The freedom of expression is an integral component of any rule of law society, whether enshrined in our First Amendment here in the US or in the Universal Declaration of Human Rights, or other domestic, regional, or international instruments. And in a world in many ways driven and buffeted by the rapidly shifting digital arena, wrapping our hands around the meaning, the parameters, the regulation, and the protection of freedom of expression in this space can be extraordinarily difficult. Our speaker today, David Kaye, is tasked with reporting on the protection of and challenges to this fundamental right across the world. It's just a very small job. As the United Nations Special Rapporteur on the promotion and protection of the right of freedom of opinion and expression, David has an extensive and challenging mandate, which includes gathering information relating to violations of the right to freedom of opinion and expression, including discrimination, threats, harassment, persecution, or intimidation against or directed at persons exercising this right, particularly journalists, seeking, receiving, and responding to credible and reliable information about dangers to freedom of expression, whether from governments, NGOs, the public, anybody else, and making recommendations on ways to better promote and protect the right to freedom of expression and opinion. Knowing David, I can say we're in good hands with him on the job. He was appointed as UN Special Rapporteur in 2014, and among many other areas, has focused extensively on the challenges posed to the protection of freedom of expression by social media and other online platforms, and the proliferation of extremist views, hate speech, incitement, and other similar content in this arena, as he will share with us today. In the course of his work as Special Rapporteur, he has conducted official missions to many countries, including Japan, Liberia, Ecuador, Tajikistan, Turkey, and Mexico. David is a clinical professor of law at the University of California Irvine School of Law, where he teaches international human rights law. international humanitarian law and directs a clinic in international justice. He previously served in the Office of Legal Advisor at the State Department, where he handled issues including international humanitarian law, nuclear non-proliferation, and criminal accountability for mass atrocities. Finally, I want to note that David's recent book, Speech Police, The Global Struggle to Govern the Internet, is available for purchase outside in Hunter Atrium, and he will be available to sign copies after the lecture. David, we are delighted to welcome you to Emory Law, and it is truly an honor and a privilege for us to have you here with us today.
Well, Dean, Lori, Professor Blank, thank you all for being here today. I especially want to thank Professor Blank for inviting me to give this lecture today, and I really encourage you, whether you're an undergraduate or a graduate or a student in the law school, take one of Professor Blank's classes. She's amazing, and the work that she's doing, as we've worked together for many years, is right at the core of so much of what's important in international law, in domestic law, in the future of war, and so forth. So I really want to encourage that, a little plug for you, Lori. So what I want to talk about today is the question of who should be making the rules for online speech. I recognize that much of the debate today is focused on very specific questions of, say, hate speech, or harassment like misogyny, or racist attack online. And there's a lot of discussion out there, both in the United States and around the world, over where the lines should be drawn as to what should be permitted and not permitted. And maybe in the Q&A we can talk about some of that line drawing. But what I really want us to talk about today is the question of who should decide. Who should be making the rules? Who should decide what's lawful and what's unlawful? Who should decide in a company context what's legitimate to be essentially public and what's not legitimate? That is, I think, a fundamental question that's at the heart of much of the debate around free speech online today. So luckily, I think I'm entering a space here where I don't need to give you a lot of run-up as to the nature of the problem, right? So of course there are problems like, this is from a view of the live streaming of an individual who committed this terrible, terrible massacre of Muslims at mosque in Christchurch earlier this year. There was an immediate question, should that be taken down? Of course it should at some level, but who should be deciding whether that particular video should be taken down and how it should be taken down? There's issues in India around, for example, what's been known as WhatsApp lynchings, right? The idea that false information and hate speech can travel across different WhatsApp groups and lead essentially to horrific offline violence. There's also, and this is just personal, there's also this kind of personal attack that one sees online that might be anti-Semitic. It might be racist, it might be misogynistic, it might be Islamophobic, you name it. This kind of content is certainly on the platforms. And of course, there's disinformation. I thought there should be maybe a speech bubble coming out of Alex Jones' mouth here, but I resisted that for here. But there's all of these different issues online, right? This is not a kind of area where I really need to ramp us all up, because I think this is one of the key public policy questions that we're facing in the United States and that people around the world are addressing today, what to do about all that content. So what I'm going to do in this talk, and hopefully I'll limit myself to about a half hour, and then we can open it up to Q&A, and hopefully I'll speak a little bit less than that, although when I say I'll speak less, I invariably speak like twice as long as I want to. What I want to do is kind of paint a picture of how content is regulated, how speech is regulated online, both in terms of what companies are doing, and when companies are regulating content, in tech land, it's called moderating content, although we know that they're actually regulating what we can say and what we can't say. Companies moderate, right? Governments regulate, and users more or less agitate. We don't have too much of a role in this framework of dealing with content online. So I'm going to start with companies, I'll then move to governments, and then we'll talk a little bit about users and perhaps an applicable framework for thinking through these kinds of problems. So what are companies doing? Companies are making rules to flesh out their terms of service. You know that page when you've signed up, although you probably signed up for most of these platforms years and years ago, but when you did, you click through, of course, yes, I accept your terms of service. You have no idea what they said at the time, of course, but their terms of service are just an overview that basically says they have discretion to decide what is permitted on our platform, what you can post, what you can like, retweet, etc. Right? Those usually get framed as community guidelines or rules or community standards. But that's what the companies are doing that we might consider as platform law. Those are their kind of constitutional rules. They have mini legislatures. In fact, the head of content policy at Facebook actually calls their bi-weekly meeting a mini legislative forum, right, where they meet and they hash out what specific rules should be, not just around a particular, say, hate speech issue, but around what should happen with political speech. How should they regulate that kind of content? We can call that a kind of platform law. There's also, in addition to all of these rules being made in Menlo Park, in San Bruno, in San Francisco, basically in the San Francisco Bay Area, there's tens of thousands of individuals worldwide who are sitting in front of computer screens, just like many of you are right now, and they're deciding what stays up and what comes down, what to delete and what to ignore, right? And then finally, there's automation, right? There's algorithmic decision-making that is basically converting all of these rules, right? It's converting the platform law into a set of automated tools so that information, content, speech that shows up on the platform that is inconsistent with the rules either gets taken down right away or it gets shunted over to one of these tens of thousands of moderators to make the call as to whether that material should stay up or be taken down. This is, in short, kind of the range of things that are happening in company space. So let me just give you a little bit of a flavor of what's happening, and I'll use Facebook. This is actually a picture that they posted. This is from their mini legislative forum. These are Facebook legislators. These are your overlords, in case you were curious about that. Right? So these are the people who are actually making the decisions. They're gathering to decide specific questions. I sat in on one of these meetings about a year and a half ago, and it was remarkable in many respects. On the one hand, it was what you might imagine it to be. Right? It was basically a group of elites, right, from elite schools from all over the country and all over the world who are gathering in this one particular conference room in Menlo Park at Facebook headquarters in order to hash out a decision about whether particular political content should be allowed or not allowed. In addition, there were people who were basically coming in through video conference from Ireland, from Italy, and from a couple other places around the world. In total, there were about 50 people who were basically making a decision about what the rules should be on the platform. Now, these rules, this is where the basic rules from the terms of service get articulated by the platforms. They look like things like this. So this is the Twitter rules, right? So the Twitter rules say that their goal is to provide a service that allows you to discover and receive content from sources that interest you, as well as to share your content with others. Twitter says, we aim to serve a public conversation, right? And their rules are designed to encourage public conversation. That's at least what they say. YouTube has very specific rules as well. Again, on things like nudity or sexual content, harmful or dangerous content, hateful content, which we'll talk a little bit more in a second. Right? So these kinds of rules are being established by the companies in processes like that mini legislative forum. Here's specifically what the Twitter and YouTube rules look like in the context of hate speech. Right? So Twitter says, they actually don't say hate speech, they say hateful conduct. So what they're doing on the platform is they're saying, look, we want voices not to be silenced. And if hate speech causes that kind of silencing, we're going to deal with it, and here's how we define it. We don't tolerate behavior that, quote, harasses, intimidates, or uses fear to silence another person's voice. If you see something on our platform that violates this, report it to us. And we'll talk a little bit about reporting and flagging in a little bit. YouTube says harmful or dangerous content, right? They, again, have a very loosely drafted rule about what they allow on the platform. Facebook is probably, and this might not surprise any of you who use all of these platforms, Facebook is the most articulated rule. They have an extensive set of rules here. They actually define hate speech. They say hate speech is a direct attack on people based on what we call protected characteristics. You could see, and then they actually define what attack is, as you see down below: violent or dehumanizing speech, statements, or inferiority, calls for exclusion or segregation. There's a little bit more on the rules that you can find if you go onto their platform, but as you see here, you see that they're actually making rules. It looks a little bit, as I call it, platform law. It looks in a way like legislation. I mean, it may be overbroad in, say, First Amendment terms, but these are the rules that they adopt. Now, Facebook is constantly, and all of the platforms are constantly restating the rules. So I was able to update this by just noting that last week, on the 12th, Facebook actually said they're updating the values that inform their community standards. And if you look down here at the last line, I'm sort of planting a seed for the further discussion in my talk. They said that we look to international human rights standards to make judgments as to what content should stay online and what should be taken down. Okay, so this is essentially the world of the platforms, like really in brief. They're making rules, they're enforcing those rules. We don't have a lot of clarity over their enforcement because they don't have anything like a case law for their work. And it's also incredibly difficult to find out when they actually take down content. If anybody has actually flagged content before that you thought was hate speech or harmful or harassment or something that fell under the rules, you probably know that it's pretty rare to get a response from the company as well. So there's all this rulemaking, there's all of this enforcement. It's happening in a black box largely, right? But it is the companies deciding what's legitimate and what's not legitimate on their platforms. Okay, so I want to move to talk about governments. So if companies are moderating content, governments are regulating. And in fact, governments are looking at these platforms. They're jealous of the power that the platforms have. I don't mean that in a kind of derogatory way. They are literally jealous in the sense that they think it is a power, at least in many respects, not necessarily in the United States, but around the world. They think that the power of deciding what's legitimate and what's not legitimate to be public is a decision for government to make. Right? That is generally their view. So what are governments doing in order to pull this back, essentially to restrain companies from having this massive power? And maybe let me just pause here for a moment to emphasize the point that these companies, at least the ones that I'm talking about today, and we can talk about smaller companies as well, but at least these massive companies, right? The Facebooks, which has over 2 billion users worldwide, or YouTube, which has well over 1 billion users, or Twitter, which is smaller but still pretty impressive worldwide. These are platforms that certainly outside the United States have a massive power over speech in the public square. In many parts of the world, and this is something that it's really important for us as Americans and thinking about American law to recognize, these are American platforms that in many respects have displaced the public square in many parts of the world. So for example, in Myanmar, formerly Burma, right, Facebook is the internet. Basically, it is the internet. The way people access information online is through something called Facebook Basics. And not only that, there aren't that many other sources, apart from radio and some broadcasts, to get a diversity of sources of information. So they have this massive power that looks almost governmental in many respects. Okay, so that's the perspective that many governments have around the world. It's not just here where there's a diversity of sources. They see these companies as massively powerful over their public space. So what are they doing? One is the governments are making direct demands on the companies. So think about a place like Kashmir in India, which for the last month, so this is a separate and very serious problem, for the last month, basically all communications within Kashmir and heading out or into Kashmir have been cut off by the government of India. Okay, so, but let's imagine a situation where there's actually communications in Kashmir. So Twitter and Facebook are really extremely important tools for journalists and for others to communicate in Kashmir. And it's also an important tool for activists. The government of India has regularly made demands of Twitter and Facebook to take down particular accounts, take down content, take down activists, take down journalists, deplatform, essentially, people who are at odds with the government. Okay, so that's one way in which governments are making demands on the companies. This sort of direct, often extra-legal, that is not through their courts, system of making demands on the companies themselves. Now, this is also happening in the West, right? So there's, and I'll talk a little bit about this, but there are tools that governments have developed over the last several years in order to ensure that their demands, particularly in areas of counterterrorism and counter-extremism, are filtered directly to the companies. So one way in which governments are pulling back on company power is through direct demands. Second is through public-private codes of conduct. This is something we saw in particular in the context of the European Union. So the European Commission essentially brought together the major companies, the three that I've mentioned, and Microsoft. They brought them together and they said, look, we need you to agree, even if it's voluntary, to a set of principles, basically a code of conduct when it comes to dealing with something like hate speech. And they've basically had the companies agree, although the scope of their agreement doesn't go much beyond what their community standards apply, but they basically got them to agree to be more transparent about the way they enforce their rules. So that's another mechanism that is taking place, particularly in Europe. Now, a third is criminalization of users and platforms. So this is a fundamental problem for freedom of expression around the world, and to a certain extent, the criminalization of users is really just an extrapolation of what authoritarian governments have been doing and we can expect to continue to do into the future. And that is where there is speech that is either, perhaps it's hate speech, but oftentimes that hate speech, when we're talking about national law, is used as a tool to undermine freedom of expression more generally. It's often used as a tool to undermine dissent against government, right? So oftentimes today, governments are looking at the online space. They're creating new laws that increase the penalties on individuals for sharing information that they think is maybe hate speech, but is, again, often dissent, increasing those penalties on individuals. But the new thing is that they're actually imposing penalties on the companies. And I'll talk a little bit about what those penalties look like. They're basically saying to companies often, if you don't observe national law and you don't observe it at the level that we expect you to observe it, we're going to impose penalties on you. And then finally, there's liability for harmful content. And this falls within the context not of criminalization, but of increasing government efforts to make intermediaries, that is the platforms, responsible for the content of their users. And we'll talk a little bit about that. Okay, so I'm not going to talk much about American law here, in part because I came here as the special rapporteur for the United Nations, and also because I wrote this book. But one thing to bear in mind, maybe to footnote for a minute and put to the side, is that in the United States, there's the First Amendment, which protects the platforms as speakers themselves, right? So it actually protects them, and this is an argument you'll constantly hear from the companies. They have a right to freedom of expression just as much as their users do. Now, CDA, this is the Communications Decency Act, Section 230, which you might have heard a little bit about. It's starting to become more of a critical public policy issue for us. It's a standard, it's a statute that was adopted a couple of decades ago, in part to encourage platforms to develop, to encourage innovation. But what it did when it created this law is that it basically gave the platforms the ability to decide what the rules are on their platforms. It gave them the ability to decide, we're going to take down this content. It may not be the kind of thing that government can take down under the First Amendment, but we're going to make the rules that we think are legitimate for our platforms and for our brand. And CDA Section 230 basically says, you're not going to be liable, company, for making those kinds of decisions. Okay? It basically immunizes the companies from their content decisions. Now, there's a lot more to Section 230, but that's the fundamental point that I wanted to make here. And there's some debate around Section 230 right now. More importantly, just for the global perspective right now, is the fact that there are these tools that governments are using in order to try to restrain the companies. So, for example, in Europol, the European-wide police network, you have what's called the EU Internet Referral Unit. This is a unit in which basically cops in Europe are deciding what kind of content should be taken down, perhaps because of either extremist, which is often vaguely defined, or terrorist content, which is also often vaguely defined. Which kind of content do they observe, and they go directly to the companies and ask the companies to take it down. Either take down content or take down the individuals or the groups that are posting this content directly. So this is one mechanism, the Internet Referral Units. And there are actually national Internet Referral Units around the world as well. And these, I think we should think of as basically extra-legal functions. These are not courts. They're not using the courts. These are law enforcement authorities making demands of the companies. We also have legal requests. Right, so legal requests that may be made directly to the companies happen not through something like an Internet Referral Unit, but they actually come through either the courts or some legal authority that's defined in national law as the right place, the lawful place to go to in order to get content taken down. So legal requests by governments, you can see this if you go to Twitter's transparency reports, you can see the range of requests that are made. You don't get much granular detail, but you do get a sense that there's an increasing number of efforts by governments to put in law mechanisms to tell the companies, you need to take down content. And by and large, the companies are responsive to these kinds of requests. They're responsive because in addition to the community standards that I was talking about before, the ones that frame what you can and cannot say on the platform, all of the companies say, we will also act consistent with national law, and we will be responsive to national requests that come through appropriate channels to take down content. Now, over the last couple of years, we've seen this move really explode. In essence, governments around the world creating new laws in order to put pressure on the companies to regulate in a maybe more open way, but definitely in a more focused way on the kind of content that they don't want to see on the platforms. So, for example, just this past spring, after the Christchurch massacre, Australia, they proposed a law dealing with what they called abhorrent violent material. And this basically focuses on live streaming and video, but not only on live streaming and video, but that's the main focus of this legislation. On a Tuesday, the government proposed this legislation, and on a Thursday, the legislation was adopted. And it basically says to any company that's of a certain scale, so certainly the companies that we're talking about, that when this kind of content becomes available on the platform, you need to take it down within an hour, basically. They're basically saying, you need to take down content as soon as it emerges. In a way, they're encouraging the companies to develop something like an upload filter, so that, and in a way, thinking of it like a prior restraint. So you wouldn't even be able to upload this kind of material. Now, putting aside whether this is a legitimate kind of law or not, it was adopted very quickly, and the idea of it, underlying idea, is that government won't be making these decisions, but companies will be making these decisions. And that, in fact, is a trend line that we see throughout these other laws. So, for example, the German NetzDG law, I won't even try to say it in German. NetzDG is the shorter version of like a paragraph-long title, right? But it's basically, it's the Network Enforcement Act. You might have heard of this because this was very well reported in the United States and around Europe when it was adopted about 2 years ago, a year and a half ago or so. NetzDG basically says to the companies, and again, to companies of scale, not to all companies, but to companies of a significant scale, it says to them, we have a certain set of laws that deal with what we might colloquially refer to as hate speech, right? So some of it is about Holocaust denial. Some of it is about Nazi paraphernalia, Nazi propaganda. But it's basically focused on traditional areas of German regulation of speech, including, by the way, insult. So there's criminal insult in German law. And NetzDG says to the companies, if you don't have a process for dealing with this kind of content, if you do not take it down, right, then you will be subject to very significant fines. And those fines can go up to 50 million euros per instance, which, you know, for a company like Facebook might not be a lot of money. It might be the cost of doing business. But they're basically saying, we're going to force you to observe national law. Now, this, again, is something we see in many other parts of the world. We've seen Singapore adopt something that isn't terribly different, although it's focused on what they call online falsehoods. We might think of as disinformation, or the, I think should be disfavored term, fake news. There are all of these rules that are starting to develop around the world. We've seen the same in Kenya, for example, although the courts there are holding that one back. The point of these laws, which I think is particularly interesting and relevant for our thinking about who decides, is that these laws do not put national courts in a position of evaluating what content is legitimate and what is not. It's not a decision that courts are making in any of these countries about lawfulness of speech. Instead, it's saying to all of these big companies, we have these rules and we want you to adjudicate them. We want you to decide what falls on what side of the line in our jurisdiction. But we're not going to make those decisions for you. You're going to be making those decisions. It's a massive, particularly considering the scope of content that we're talking about, it's a massive outsourcing of what we might think of as a public decision-making process, right? It's basically a process in which companies that lack democratic accountability, lack transparency, and very significantly lack appeals mechanisms, they are making these decisions, okay? That's what's actually happening in much of this space. So again, on the one hand, you have companies that are moderating content, they're making rules, they're doing it for themselves because of the platforms that they want to have, they're doing it because of public pressure. Then you have governments that are pulling back on that. They're saying, we don't want you to be so making these decisions only on the basis of what you think is right. We want you to do it on the basis of our laws. And yet that's causing significant problems because it's just an outsourcing of decision-making. And then throughout this, there's a question of where do users fit, right? Particularly when we see all of this platform law being made, where do users fit into that issue? Where does the public fit into that? So, of course, users have the ability to flag content, which is both a positive and a negative, right? The advantage is if you see content that you think is hate speech, or particularly if you're the target of it, you have some tools, you can flag it, you could block the user, there are certain things you can do. That's a positive. That's a form of user autonomy that we should be really embracing. On the other hand, the flagging of content also allows essentially trolls and mobs, right, to determine what's legitimate and what's not. Because when you have mass flagging of material that might be coordinated and may be inauthentic, it may be caused by bots, for all we know, that kind of process also causes the platforms to make decisions about content that might actually not be related to the content itself. It may be because of political disagreement or dissent or something else. So there's both advantages and disadvantages to the power to flag content. Now, users do have tools of litigation and advocacy, and I'm going to come to that in a second because one of the most prominent instances of platform regulation actually was not something that was developed by government, but was developed by an individual who litigated. Other than these, basically, users are non-participants in platform rulemaking. Of course, you can imagine hashtag delete Facebook or something like that. That doesn't have a whole lot of power globally. If you've noticed, the stock for all of these companies is continuing to rise. They're still popular. They're still gathering new users on a monthly basis. So basically, users are left out of the decisions right now around platform regulation. Let me talk just briefly about the possibility of litigation as a tool. So you might be familiar with the right to be forgotten. So the right to be forgotten as a new rule really just developed in 2014 in Europe, right? As a tool for moderating or regulating content did not develop simply because government decided, okay, this is something we want to change. We want to protect our users' privacy. We want to protect them so that, or at least our citizens' privacy, we want to protect them so that irrelevant material that may be online won't live online forever. That wasn't a government decision. It was a decision essentially of one advocate, of one victim in Spain who wanted to get rid of, and I won't go into detail on this because it would take another 20 minutes to go through it, but essentially one individual in Spain who no longer wanted an old bankruptcy to appear online. When you searched his name on Google, he sued Google, and the European Court of Justice, the top court in the European Union, sided with him and said that the companies have to offer users the opportunity to apply to have their name delinked from any searches that may take place on their platforms. They didn't say that, for example, if your bankruptcy was posted in a Spanish newspaper, that the Spanish newspaper needs to take it down. They said that the search engine needs to make it very difficult to find you if they search your name for a particular reason. And what this resulted in was Google Spain, this decision that was adopted in 2014. Again, it was adopted because of the work of this one individual and advocates who supported him. And what we have now is, if you are in Europe, you can petition to have content taken down. And if you look at this, you will see that there's this form, and then Google says to any particular applicant to have a link removed. We will balance the privacy rights of the individual with the public's interest to know and the right to distribute information. Look, on sort of a purely moral basis or legal basis, this is not a terrible set of balancing that we might expect government to do, right? But keep in mind, this is a balance that Google is conducting. Google is making a decision as to whether the privacy rights of an individual should outweigh the public's right to know. That's a pretty massive power for a company to have. And this is essentially the kind of rulemaking and lawmaking that we're expecting these companies to do generally across the board, not just in the context of the right to be forgotten, but in the context of hate speech, of terrorist content, of harassment, and other interests and values that really intersect the public and the private around the world. Okay, so we have companies moderating, we have governments regulating, we have users, more or less, agitating or completely in the dark. So what does that mean for us? What are the questions that arise from this? How should individual rights be protected online? How should people and communities be protected online? How should their freedom of expression be promoted? What laws should govern online speech? These are essentially the questions that governments and the companies around the world are grappling with. And this, I think, is one of the fundamental ones. Should it be law that's making these decisions, or company policies and terms of service? This is at the core of the debate around the world. Who should be making these rules? Should it be publicly elected representatives, certainly in rule of law, democratic societies that make these rules? Should it be jurisdiction by jurisdiction? Or should it be the companies that simply make up the rules based on their own idea of what free expression on their platforms means? I mean, hopefully we can talk a little bit about that. I'm not giving you a firm answer on who should have the balance of that right, but I want to give you one framework for thinking this through. So I think that one valuable way of thinking about the companies is through something called the UN Guiding Principles on Business and Human Rights. You thought this was all going to be about tech. Now I'm a human rights law professor, so of course I'm going to talk a little bit about human rights. So the UN Guiding Principles on Business and Human Rights were adopted just in 2013, and they have three pillars, basically. One is states have an obligation to protect human rights. That's not controversial. We know that. That's human rights law, right? When you ratify a treaty under human rights law, or if we're talking about customary norms of human rights law, those apply directly to states. States have obligations. Under those treaties, unless the state legislates something further, the companies don't have any particular obligation. So the middle pillar of the UN Guiding Principle says companies have to respect human rights. And that means, given the fact that human rights law is not only about what governments cannot do or what they should promote, but that it's also about individual rights to enjoy certain values. So for example, the right to freedom of expression says everyone shall enjoy the right to seek, receive, and impart information and ideas of all kinds. That's focused on the individual. It's not Congress shall make no law, it's every individual enjoys this right. So what the respect principle of the UN Guiding Principle suggests is individual companies should essentially conduct a kind of human rights impact assessment to determine whether what they're doing interferes with those individual rights, whether it's freedom of expression or anything else that might be in the corpus of human rights law. I think this is an appropriate way for us to think about the companies, given the massive impact that they have worldwide. And the third pillar is remedy, right? So the companies should not only be in a position to evaluate the rights of their users, but where they interfere with the rights, there should be a remedy. Either it's available from the company or it may be available from government directly. That's the UN Guiding Principles on Business and Human Rights. So, of course, there is human rights law that's relevant to this subject. This is from the International Covenant on Civil and Political Rights, although I guess I cut off the law part. This is not intentional, meaning this isn't exactly law. Human rights is law, trust me, I promise. So this is Article 19.2, right? It says that everyone shall have the right to freedom of expression, which is what I just described. It also says that states may restrict expression when it meets certain conditions. So for example, as long as the limitation on expression is provided by law, which typically means something, you might think of it from constitutional law, like a void for vagueness kind of obligation, right? An obligation that law is adopted through regular process and that it's precise and clear enough to guide individual behavior. That's provided by law. It also should be necessary, which is understood to be necessary and proportionate to meet these specific legitimate objectives: the rights, respect of the rights or reputations of others, protection of national security or public order, or of public health or morals. Okay, so that's generally what applies to states, but I think that's a good framework for companies to think about as well. There's also Article 20 of the ICCPR, which is essentially the hate speech provision, which says that any advocacy of national, racial, or religious hatred, that's your hate speech part, that constitutes incitement to discrimination, hostility, or violence shall be prohibited by law. If you think about this framework, and we can certainly discuss some of the particulars here, this framework actually is much more in line with what the companies are doing in many respects than what, for example, the United States under the First Amendment might allow. This is actually, I think, an appropriate formula for thinking about global rules. It doesn't mean that states can't go beyond it and be more protective of human rights, but this provides us with a global standard that, frankly, all of the companies have been saying, we need a global standard, we need a global standard. Well, here you have it. So let me conclude with a set of ideas about what a human rights law approach to online speech would involve. So I'll start with the private companies and tech. There's this overarching question of the legal environment, what shall apply. They are conducting themselves as if they have platform law. I think that we should be talking about a few different principles. One is user autonomy, control, and education, right? So that means that users should have the ability, right, to control their information space. That might mean blocking or muting users, but that also means having control, for example, over the algorithms that are making decisions about what you see and what you can't see. That's very unlikely to happen under the current business model of any of these major companies, but my response to companies that complain about that is sort of tough luck. They've become ATMs for their shareholders, but they're causing significant problems, and if they want to actually give users the ability to control, that's something that they would need to do. There should always be humans in the loop. So one of the problems with our algorithmic approach is that we risk allowing algorithms or artificial intelligence to make decisions without a human making any particular call as to whether content should be taken down or not taken down. This is, at this moment in technology, this is virtually impossible for algorithms to do when it comes to speech like hate speech. There needs to be humans who are part of the decision-making process. We need to have transparency. Transparency is like our principle of provided by law, right? We don't really know what the companies are doing in order to enforce all of those rules. We don't know how they're adopting those rules, and we need to have clarity as to how that's happening. I think there should be something like decisional transparency, which would be case law of some sort, keeping in mind privacy interests of individuals, but I think this kind of tool would get us further. And then finally, multi-stakeholder engagement. So right now, essentially we're talking about companies making decisions on their own without too much involvement from the communities where they're regulating speech. That's a deep problem if you're in a place like India, which has multiple markets, basically, and the company has virtually no insight into the code that constitutes hate speech in the country, or extremism, or whatever it might be. They need to have more engagement. That means getting more stakeholders involved in their decision-making. And then on the state and regulatory side, one is intermediary liability, right? So as we're thinking about things like Section 230 of the Communications Decency Act, or its analog in Europe, which is the e-commerce directive, there are moves to make companies more liable, as I was suggesting, for the decisions they make about content. I think we need to ensure that when those decisions at a legal level are made, at a legislative level are made, they should be made in accordance with basic principles of necessity and proportionality. And why is that? Because if there is too much regulation of the companies, there should be some regulation of the companies, but if there's an over-regulation, who will be harmed by that but the users, those who are seeking information and seeking to speak on the platform? There should be focus on the business model and not content discrimination. In other words, competition policy, right? Business model issues like consumer protection, issues around algorithms and the way in which algorithms preference the sensational over other values that the users or the public might have. And then there should be a role for an independent judiciary. As I was suggesting, most of these new rules are outsourcing actual decisions to the platforms themselves, to the companies. I think that that's going to happen no matter what kind of regime we imagine, but at a basic level, we need to have fundamental rule of law standards and rule of law institutions like judiciaries, like our courts, that make these decisions. And then finally, just as there should be transparency for the companies, there should also be transparency by governments. When they are making demands on the companies for the takedown of certain kinds of content, they're virtually, like with some exceptions, they're virtually never providing the public with transparency about those demands. That should be public as well. So with that, I will conclude. I'm sure I went over my allotted time, but I'm happy to take questions and turn it over to Lori. Thank you.
Thank you very much. So we have time for some questions. We have 2 microphones. I'll let you pick your
I'll pick 'em?
questioners, and
Okay.
we'll walk the microphones around.
Okay. Right here in the middle.
Hi. So my question is, you outline a lot of the current internet regime as being companies having broad autonomy to regulate their own platforms. Definitely countries passing laws that more or less quid pro quo fine companies for non-compliance with certain restrictions that they see are, within their jurisdictional rights to enforce. How do you bring this legal framework that you've outlined to fruition? Like, how do you get companies to come to the table to do things that are based off of my experience, not in their own interests?
They're what?
Based off of my own experiences, not in their interests.
Right.
Lots of these regulations are going to require more work for them
Yeah.
to be able to to enforce, and it just seems like that they might not want to do that.
They definitely don't want to do anything that I suggested. So the companies, look, I think that we have power as a public, right? And there's 2 ways to think about this. So first of all, I think there is some agitation for, certainly among a human rights-oriented community, for the companies to adopt rules that are in keeping with the human rights of their users. So there is some of that that's already happening. There is more or less an openness of the companies to have that kind of discussion. And if you think about the kind of debate that's been happening, for example, in Europe, I mean, we as Americans don't really speak human rights, but the language in Europe has been focused around human rights law, and it's forced the companies to think about whether their rules should be more in keeping with the human rights of their users than in some kind of generalized way, more akin to the kind of First Amendment culture that most of the employees of these companies, certainly their general counsels and content policy people, are used to. So one thing is there's public agitation for this. A second part is you could imagine governments, instead of just saying that we want your standards to be following our national law, although that will always be a principle that we can expect of governments. But they could also say that your community standards should be in line with human rights law. I mean, they could legislate that, and they could start, if they're not going to start with, let's say, the content-specific issues like hate speech law, they could focus on, for example, the provided by law standard, and governments can legislate transparency. They can say, look, if you want to operate in our environment, you need to report to us on, and they can give some periodic table of how often they should be reporting. So I think there's work that both governments and users can do to force the companies to be more alive to the nature of their impact on societies around the world and to apply rules that are more consistent with human rights law. It's not easy, and the companies have huge amount of power, huge amount of lobbying power in Brussels and Washington, but I think there is a kind of tide against them in many places that this might be a moment to think these through. In the back, see Professor Dudziak, if I'm right. My eyes aren't working as well as they used to, but that happens when you pass 50. But.
No need for eyes to work when you're giving a talk. Thank you so much for this really interesting talk and important talk, which I shared with over 9,000 people on Twitter as you were speaking. So, hopefully I didn't mischaracterize you. But as you were talking, I was thinking about where there are sort of parallel issues in another realm where there's massive amounts of information and a public right to know, and that's U.S. government declassification. So it's not an international issue. But my question for you, sort of coming from where the future looks in that area is your emphasis on the importance of the human in the process in a context where, we're just going towards AI all over the place. I appreciate your comments about sort of the importance of problems with algorithms, et cetera, but at least in the declassification, if you can imagine, we're talking about secret government documents or documents with private information on them. And yes, they're developing tools to use AI in part because that will actually, at least arguably, enhance a public right to know and keep from spending countless millions on human government worker time. So there's sort of all sorts of costs, including, what it is we're spending our human power on. And that would carry over to the private companies also. So in spite of my deep skepticism about artificial intelligence in both of these realms, don't you think that's the future? And isn't it important to, rather than keeping hold of the human, which is basically going to become less important, putting more attention into enabling us to have some level of public governance in a context where AI is going to become more and more important?
Yeah. So I think you're absolutely right. So let me just say one thing about AI and these platforms, and I'll put it in the context of what YouTube has reported as the amount of content that is uploaded per minute. I don't know if anybody knows that number offhand. They've said 600 hours. So 600 hours of video are uploaded every minute. Now, most of that is, I guess, cat videos, but there's a certain percentage of it, even if it's minuscule, right, that might be problematic under their policies. And then, you multiply that out, or you look at it from the context of Facebook, which is an even bigger platform, or Twitter, and you're talking about massive amounts of data. And in that context, I think AI can be a friend. There's no question that algorithmic evaluation will have to be part of at least filtering what's inconsistent with those rules and what's not. So the way it works at the moment is basically the companies have tools that very often fail, but they're algorithmic tools that move that material that they find to be problematic to individuals who are deciding what should come down and what should not. And so that, from when I talk about a human in the loop, my point is that's important to continue to happen. That where there's algorithmic filtering, that should be going not just simply to some memory hole and we lose that content entirely, but it should be going to some individuals who can make the call as to that particular content. With video, you could imagine, although video is easier than language because AI has a very hard time with natural language processing. So they have a hard time identifying, what is hate speech when it's written down. It's a little bit easier for it to see, say, video that has a beheading, just using the most extreme version, and knowing that that's something that is not to be on the platform. It knows how to do that, but where you need the individual in the loop, the human in that loop, is in the context of determining whether that, let's say, awful content is posted as part of a news report. Maybe it was part of journalism and an effort to get information out to the public. That's not something that the algorithms right now are very good at. So that's maybe to put in a framework what I'm thinking about in terms of the role that AI can play. My biggest concern, frankly, is a move that we're seeing mainly in Europe right now, and that is, and I mentioned this sort of in passing, the idea of upload filters. So this is the idea, and this is where a lot of Europeans are pushing the companies, and unfortunately, the companies are saying, sure, we can try to do that. Basically, they're saying, where there's bad content, it shouldn't even be subject to upload. So there'd be some mechanism that when you try to upload content, it won't even make it onto the platform. That is a problem that is almost certainly, it already does this in the copyright context. It will remove a tremendous amount of information to which there's a public interest, right? So I can't really compare it to, say, freedom of information and declassification, but I think that what we're seeing on the platforms, and we're seeing in terms of public or governmental pressure for more AI, is something that we might see and might have some valuable role in other parts of our public lives. But in this particular context, when we're talking about this particular kind of speech, I think that the human in the loop is going to be, just continue to be essential moving forward. I hope that answers at least part of the question. Yeah. So, got a question here. We'll move to this side of the room. Yeah. Thank you.
So, listening to a lot of the concerns about, speech and hate speech and all that kind of stuff, I feel like we had similar, not identical, but similar discussions regarding AOL, MySpace, those kind of companies about 15 years ago. And if you go back 100 years, there's even related concerns with yellow journalism, stuff like that in the past. So I guess what I'm asking is that by subjecting Facebook and other large companies like that to regulation, whether or not we're really just opening the door for regulatory capture and sort of enshrining these companies as anti-competitive monopolies for decades. Because I don't think it's a coincidence that Facebook, which has been anti-regulation for 10 years, after the Cambridge Analytica scandal, Zuckerberg goes and testifies and says, look, I think it's about time for some regulation. We'll help you write the rules. Yeah. So I guess my question is just how do we avoid regulatory capture? And maybe some of these problems don't need government intervention to be solved.
Yeah. So yes, I mean, that's a really important point. 2 points, really separate, right? So one is, at a certain level, many of our issues around speech, and particularly corporate regulation of speech, are pretty old, right? I mean, whether you go back 100 years and you talk about regulation of broadcast, of radio, and so forth. I mean, we've always had these kinds of debates, right? And we had them 20 years ago when we were just talking about bulletin boards, online bulletin boards, right? So to a certain extent, this isn't super new. I think one of the new issues right now is that, so back in the day, like more than 15 years ago, right, you basically had a kind of flat sort of process where you had blogs, you had bulletin boards, you had all of this world of speech that was happening, but it was happening in many different parts of the web. What changed 15 years ago, 15 years is a good point to make because that's the year that basically Facebook and the other companies come online, they start to change the concentration of information, right? So what did that mean? That meant that suddenly you had, and it really is, like historically speaking, sudden, that suddenly you had these companies having massive power over expression for the public. Again, it's a big change from the blogosphere to social media, and I actually start the book with a discussion of this, because what you saw change was, on the one hand, you had companies with massive power over speech, like in a way that, sure, MySpace or AOL bulletin boards, whatever, they had control, but they were moderated and they were smaller. This was suddenly massive scale and massive power. At the same time, because you had social media basically organizing so much speech and information, you gave countries, you gave governments a way to say, oh, we don't have to go scouring the internet for bad content anymore. We could just go to Facebook. It's all there, or it's all on Twitter. That's what they cared about more than ever. Now, we've seen in the last year and a half that there are other platforms, or 2 years, that other platforms like 4chan and 8chan matter too for a lot of this. But this has been a concentration. So I think that is a difference at a certain level. It is a kind of monopolization of the access to information. Less so in the United States, although still real here, more so in many, many parts of the world. Okay, so given that, and we talk about regulatory capture and regulation, one of the problems that a lot of analysts in Europe see right now is that this move to put more responsibility on the platforms is something that only the very big and wealthy platforms can do. And so instead of actually creating this system of control over these companies, it's actually allowing the companies to have more power, right? Smaller startups can't afford to do the kind of moderation that these companies are being required to do by European governments. So that's one part of the regulatory puzzle. How do you impose some obligations on these companies that will be expensive obligations and do it in a way that doesn't crowd out competition in the future? So that's one particular problem. And that is why I think Zuckerberg and others are like, bring it on, right? We can afford it. Not many others can do it, so this will lock in our power. How to deal with capture more generally, I'm sure there might be regulatory experts in the room, but this is also a fundamental problem of our democracy, which, I mean, I can't solve much as I would like to, but the power of any company and any industry to capture the regulatory process is in part a function of our lack of transparency, our lack of regulatory control over, sort of a meta control over that process. And I don't really have a good answer to that, except to say that these are the puzzles that are involved right now when we're talking about regulation and moderation of content. I don't know how much time we have. Yes, please, over here.
Hi, I'm wondering how you foresee these policies affecting the posts of world leaders, for example, like Donald Trump. So kind of like access to information versus potential hate speech.
Yeah. This is a problem that the companies are trying to deal with all the time. And so they solve it by saying, okay, so you've got someone like Donald Trump, although there are many others. Like you could think about, and actually I do want people to think about this in a global context, right? It's not just about Donald Trump. It's about, your military leader in Myanmar who is inciting violence against Rohingya, or in Sri Lanka, or go down a very long list, sadly. So one thing that the companies say is, look, we have our rules, and we expect everyone to abide by these rules, whether they're hate speech or offensive content or whatever it might, harmful content, whatever it might be. But we might not apply the rules if it's newsworthy, or if it's in the public interest to see that information. Okay, so that is a standard. It goes back in a way to Professor Dudziak's question about declassification. So declassification that's made by government officials, often by lawyers who are making decisions about where to draw those lines. Right now, for the public interest / newsworthy, we've got the companies making that kind of decision. From my perspective, I understand what they're saying, like that there is a public interest, much as I would never retweet certain political leaders. I won't go further than that. I think there is a public interest in seeing what people are saying. You learn a lot about someone's mind by seeing their tweets. But there are tools that the companies can use, and Twitter has started to unveil this, although I don't think they've implemented it quite yet, is where they could say, look, this violates our rules, but it's important for the public to know that it's out there. So we have other tools that would, for example, make it less likely for that particular tweet to go viral, make it harder to find it. We're not going to take it down all the way. And if you want to go look at this person's page, you can see all of their tweets, but we're not going to make it as easy to share. I mean, that's another sort of technical tool that companies can be using. It remains a form of moderation or censorship, depending on where you see what the companies are doing. But it is a tool that they have that they could use that allows them to satisfy both of those things. But again, it's a public policy kind of question. And I haven't answered this question because I myself am trying to to figure out, like you are, hopefully, what's the appropriate set of standards here. But we as a society and globally around the world, people have not come to a consensus on how those rules should be implemented, how they should be designed, what the role of the public should be in enforcing them or helping design them, the role of accountability, all of that, it's still very open to question. So I think that was the last question. Yeah. Okay, great. Well, thank you very much.
Okay, thank you very much. And again, I think there's some books outside for any of you who are interested in learning even more. So thanks.
Thank you.